The Long-Term Care Homes Act of 2007 came into effect on July 1, 2010. The regulations under the Act set out the requirements with respect to how long-term care homes must operate and provide healthcare delivery to residents that live in long-term care homes in Ontario. Section 3 of the Act includes the Residents' Bill of Rights. The Residents' Bill of Rights provides rights and protections to residents that are to be respected and complied with by all staff and healthcare providers or the care team that work in these homes. Paragraph 11 of the Residents' Bill of Rights states that every resident has the right to give or refuse consent to any treatment, care, or service provided by the long-term care home for which his or her consent is required by law, and to be informed of the consequences of giving or refusing consent. This means that each competent resident or the resident substitute decision maker has the right to make their own decisions concerning all aspects of the resident's care. This decision-making right must be upheld and respected by the entire care team. Open dialogue is the key to both upholding the resident's right to making their own decisions related to care, as well as consent from the resident or substitute decision maker when providing any personal assistance services. A healthcare professional or a member of the care team must obtain informed consent to treatment where required by law, as well as consent from the resident or substitute decision maker when providing any personal assistance services. This is an important part of building open communication between the resident or the substitute decision maker and the care team.
Good morning, sir. Welcome to Queen's Garden. My name is Jane. I'm the administrator here.
Hello, Jane. My name is Andy.
Nice to meet you, Andy. And this must be your daughter, Candace. Candace, nice to meet you. Welcome to Queen's Garden. Thank you.
Good morning, Mr. Thompson. Welcome to Queen's Garden. My name is Lori, and I'm the nurse manager for third floor. And I'd just like to welcome you to Queen's Garden.
Hello, Lori. Hello. You may call me Andy.
Thank you. For the next few minutes, we'd like to discuss how we can best meet your needs here at Queen's Garden. But before we begin, we'd like to discuss any health issues that you'd like to share with us.
Well, I'm a diabetic, and I'm concerned about how the treatment would go here. I like to read a lot, and I like to build some model airplanes at times, and sometimes I don't feel too well. I think that is my diabetes.
It could be. That's why we need to take a few moments to get to know you, to go over your medical history, to find out any problems you've had in the past with your diabetes, and to make a plan of action, to speak with the doctors, organize your blood work to see what's going on there so that we can go forward with a plan of care for you.
The residents or substitute decision makers' participation in the development of the initial plan of care should be the starting point for open dialogue about planned treatments or courses of treatment and the foundation for obtaining informed consent. Section 6, subsection 5 of the Long-Term Care Homes Act requires that residents or their substitute decision maker are able to fully participate in the development and implementation of the resident's plan of care. This care planning process starts on the day of admission and will continue as the resident's health condition, preferences, and wishes change. The Long-Term Care Homes Act also requires that whenever the care team reassessed and revised at any time the resident's plan of care with respect to treatment, the team must obtain informed consent from the resident or substitute decision maker in relation to the new revised plan of care. The resident's consent and any revisions to the plan of care should be documented as part of the resident's health information record. Informed consent is defined in Ontario's healthcare consent legislation in order to ensure that a resident or substitute decision maker is provided with the information reasonably needed by them to make a particular treatment decision, and to ensure that the healthcare provider has answered any questions or provided additional information about the treatment requested by the resident or the substitute decision maker. A consent to treatment is informed if, before giving it, the resident or substitute decision maker receives certain information about their care that anyone in the same circumstances would require in order to make a decision about the treatment, and the resident or substitute decision maker received responses to his or her request for additional information about all aspects of his or her treatment and/or care. Ontario's healthcare consent legislation also provides direction to health professionals regarding what information they should provide when obtaining informed consent. The resident or substitute decision maker must receive information regarding the nature of the treatment, the expected benefits of the treatment, material risks of the treatment, material side effects of the treatment, alternative courses of action, and any likely consequences of not having the treatment. This means that the resident or his or her substitute decision maker must be informed of what the treatment or plan of treatment includes, the benefits and risks of the treatment or plan of treatment that would influence the decision being made, as well as any information of alternatives to the treatment or plan of treatment, and the consequences of not having the treatment or plan of treatment. Once the resident or substitute decision maker has had the opportunity to consider this information, he or she can either indicate their consent to proceed or their refusal to proceed with the treatment or plan of treatment. The resident or substitute decision maker may also withdraw any consent to treatment or plan of treatment at any time. Their decision about treatment must be respected and followed. Over time, a resident's health condition will change. Therefore, the Act requires that every resident be reassessed and the plan of care for each resident be reviewed and revised at least every 6 months or when a goal in the plan is met, the resident's care needs change, or care set out in the plan is no longer necessary, or care set out in the plan has not been effective. Ontario's healthcare consent legislation contains specific requirements for obtaining consent to treatment or a plan of treatment. For instance, a resident's or substitute decision maker's consent to treatment must relate to the treatment, must be informed, must be given voluntarily, and must not be obtained through misrepresentation or fraud. A consent to treatment given by or on behalf of a resident may be withdrawn at any time. It is important to understand that not all interactions between a healthcare professional or the care team and a resident are considered a treatment within the meaning of Ontario's healthcare consent legislation. Treatment means anything that is done for a therapeutic, preventive, palliative, diagnostic, cosmetic, or other health-related purpose, and includes a course of treatment, plan of treatment, or community treatment plan. However, a treatment does not include the admission of a person to a hospital or other facility, completing a capacity assessment, examining a person to determine their general condition, taking a person's health history, communicating an assessment or diagnosis to a person, providing treatments that pose little or no risk of harm, providing personal assistance services. According to Ontario healthcare consent legislation, every time a healthcare professional proposes a new treatment or plan of treatment, informed consent by the resident or substitute decision maker is required. At the same time, Ontario healthcare consent legislation allows the health practitioner to presume consent to variations or adjustments to the treatment or plan of treatment. These variations must not significantly change the risks, benefits, side effects, or nature of the treatment or plan of treatment.
What happens if there are some tests that I don't want or some that I would rather do differently?
That's why we have to go over the plan of care with you. We need your consent to perform any tests, give you medications, any treatments that best suit you. So that's why it's very important that you're involved in the admission process, and we want to make sure that your activities here at Queen's Garden meet your expectations.
Any resident is also entitled to answers to any questions they may ask about the treatment.
I'm Sue. I'm the social worker here at Queen's Garden. I usually visit people who have just moved in just to see how they're settling in. And at any time, if you would like to talk to me, feel free to ask the nurses and I'll come and see you.
Hi, Sue. What happens if I don't want a social worker to visit me?
Andy, you certainly have the right to refuse or change your mind at any time. So if I had a visit scheduled with you and then you decided you didn't want it, you can change your mind at any time.
Under Ontario healthcare consent law, healthcare professionals, such as nurses, doctors, therapists, must obtain informed consent from the resident or the resident's substitute decision maker before providing treatments for a health-related purpose, including a plan of treatment. A resident's or substitute decision maker's right to make decisions about the resident's care must be respected by the entire care team. Healthcare professionals in long-term care homes must obtain informed consent to treatment, including a plan of treatment. In Ontario, there are several legislative and regulatory requirements as well as resource tools established by regulatory colleges for healthcare professionals that set out the standards for documenting health information of patients and/or residents. These standards are aimed to ensure that an accurate picture of the resident's needs, any interventions or treatments, and the outcomes of these are kept in the resident's personal health information record. This includes documenting the consent that the resident may give or withdraw during the course of their care and/or treatment while living in the long-term care home. This applies whether or not a consent to treatment form is obtained from the resident or the substitute decision maker. The Ontario Healthcare Consent legislation does not require health practitioners to use a consent form to document informed consent. The decision to use a consent form is up to the long-term care home. If the long-term care home uses a written consent form to obtain consent with respect to treatment, this document is considered a regulated document and must be certified for compliance with the Act by a lawyer. The Act does require that any document containing a consent or directive in relation to treatment, course of treatment, or plan of treatment must be reviewed and certified by a lawyer with a copy of the signed document provided to the resident or substitute decision maker. Therefore, any consent to treatment forms to be signed by a resident or substitute decision maker must be certified by a lawyer.
I have another question. What happens if I can no longer make decisions for myself? Who is going to provide the consent on my behalf?
That's why we recommend that you designate a power of attorney for you in case you can't make decisions for yourself. That could be a family member, that could be a friend.
So, Laurie, what happens if I make my daughter Candace the attorney to make the decisions for me, and my 3 sons, who are rather strong-headed, disagree with her decisions? At that point, I won't be able to stop anyone doing anything.
Well, it's always the resident who decides who the attorney for care is. We have to follow the directions of whoever you've chosen. That's the law.
Sometimes a resident may have appointed a family member as an attorney for care, but another family member who visits the resident more often feels he or she has a better understanding and awareness of the resident's wants and needs. It is up to the family to resolve these issues. The care team in the long-term care home can only follow the directions of the attorney for care appointed by the resident. Many of the day-to-day care and services provided to residents in a long-term care home, especially those provided by personal support workers under the direction of the nursing staff, fall under the definition of personal assistance services set out in Ontario's healthcare consent legislation. Personal assistance services include assistance with or supervision of hygiene, washing, dressing, grooming, eating, drinking, elimination, ambulation, positioning, or any other routine activity of living, and include a group of personal assistance services or a plan setting out personal assistance services to be provided to a person. While consent is required for personal assistance services, it may be implied by the resident's admission into the long-term care home and his or her participation in the services. This does not mean that the care team simply goes ahead without including the resident or the substitute decision maker in the decision making about the provision of these personal assistance services in a long-term care home. The Resident's Bill of Rights includes the right of every resident to participate fully in making any decision concerning any aspect of his or her care. Most importantly, because many personal assistance services are by nature very intimate, invade a resident's personal space, or require physical contact with the resident, care team members must obtain the consent and cooperation of the resident before providing these personal assistance services in order to respect and protect the resident's dignity, safety, and comfort. Ontario healthcare consent legislation does not require that the resident or substitute decision maker's consent to treatment or to receive personal assistance services be provided in writing to the care team in the long-term care home. Consent can be provided verbally. A signed consent form is not required in every situation. A care team in a long-term care home must determine when it would be appropriate to have a resident or substitute decision maker sign a consent to treatment form. Documentation related to the provision of personal assistance services should be guided by the health practitioner's professional guidelines and any relevant legislation and the policies of the long-term care home. To summarize, a resident's or substitute decision maker's right to make decisions about the resident's care must be respected by the entire care team. This includes respecting residents' participation and direction in making decisions about their care and their decision to give or refuse consent at any time. Healthcare professionals or the care team in a long-term care home must obtain informed consent to treatment and/or plan of treatment before providing the treatment. Personal assistance services are not considered treatment under Ontario's healthcare consent legislation. However, care and services to a resident cannot be provided without consent. Residents or their substitute decision maker must be given an opportunity to participate fully in decisions about these services. Residents or their substitute decision maker may also withdraw at any time consent they have previously given. Finally, consent is all about effective communication by having ongoing conversations with residents and their families about the residents' wishes and decisions throughout their care, and letting them feel they are part of the care team.